On some general issues, just remember there has to be a tenancy. Something that gets people rather confused is that if you have created a tenancy and then at the end of the term you issue a new tenancy with a 6-year term, then that is not the 6-month tenancy that is protected, that is excluded from the operation of the 54 Act. I dealt with a horror story years ago where the clients had entered into a lease for a 10-year term. At the end of the term, the landlord and tenant had agreed a new lease for a period of 6 months. And then the landlord argued that that new lease couldn't be protected by the 54 Act, when the reality is it could, on the basis that it, in essence, was simply an addition to the original lease. As far as tenancies are concerned, it is important to look at the lease, look at the wording to make sure that we're satisfied that we are dealing with a lease. If we're looking at licenses or tenancies at will, etc., then again, just check the wording. Where a license or a tenancy at will has expired and the tenant is still in occupation and still paying rent, remember what I said about an equitable tenancy potentially arising, generating protection to the 54 Act potentially. What can we extract from Street and Mountford? Well, the important point here is that licenses could well be a license if that's what the parties intended and would be out with the 54 Act, but could in fact be tenancies which are 54 Act protected. And remember, Street and Mountford was a case involving residential property, not commercial property. What do we mean by occupation? Well, the important point here is that what we're talking about is the tenant or the applicant or respondent in proceedings being in situ. But as far as occupation is concerned, when the 54 Act first went live, litigators would frequently argue about who the tenant is on the basis that the original lease was entered into by a parent company and the occupant is now a subsidiary. These days, if there's some form of connection or nexus between the party named as the tenant in the lease and the party in occupation, they're deemed to be one and the same. But we could have, and we do see from time to time, situations where the original lease is in the name of tenant 1 and the person or entity that's in occupation is tenant 2. From a landlord's perspective, I wouldn't get too excited if that is the case on the basis that the tenant 2 could have an equitable tenancy. I go back to the point that I made earlier, that an oral tenancy can be an equitable tenancy and an equitable tenancy can be 54 Act protected.